Can I go ahead, sir?
Wait a minute, sir. I will. Yes, sir.
Yes, thank you, sir. So please move on with the first slide, sir.
Yeah.
Right. Let me begin with the brief introduction to this intellectual property rights. As you all very well know, these intellectual property rights are the rights created over the property, which is a creation of human mind. Probably for the last 3-4 days, you would have exclusively discussed about patents. Other than the patents, there are other 6 forms of intellectual property rights recognized throughout the world, which includes copyright, trademarks, designs, geographical indication, trade secrets or confidential information, etc. And these intellectual property are the knowledge assets created through the manifestation of ideas, and it is conferred on the creators as exclusively or exclusive statutory rights for intangible knowledge assets. What I mean to say here is, we have a statute which protects the intellectual properties. Except confidential information, every other intellectual property is protected by the statute, and confidential information and trade secret is protected through the Indian Contract Act 1872 and through Specific Relief Act 1963. And this intellectual property is a tradable commodities like any other right, and these IPR rights are enforceable by law. This is the main issue that we are going to focus upon today when I talk of offences relating to IPR and cyber crimes. Ultimately, you can own intellectual property rights, no doubt. But the greatest challenge is that how do you protect it? That is the biggest challenge that one has to understand. And what law says as far as protection is concerned. We have the Patents Act of 1970, the Trademarks Act of 1999, the Designs Act of 2000, and the Geographical Indications, Registration and Protection Act of 2000. Likewise, each form of intellectual property is protected by a statute, a law. Except, as I told you, we do not have any exclusive law in India to protect confidential information or trade secrets, which is in fact protected by the Indian Contract Act 1872 and Specific Relief Act. That is, I mean to say there is no exclusive law, separate law to protect confidential information or trade secrets. And moving further, these intellectual property rights play a more important role as assets for an enterprise than physical assets. It was reported last week, the Madhya Pradesh High Court has applauded a mediator for settling the trademark dispute involving 5,000 crores. Look into the nature of dispute. 2 companies came with a tug of war to settle a trademark dispute, which was worth 5,000 crores. Let me give you some of the simple examples in and around Mysore so that you can understand the concept of the intellectual property rights very easily. Probably, if you are from a Mysore, you would have heard of the restaurant by name Aigiri, which is situated in Kantrajas Road, just opposite to JSS Law College. That hotel wanted to have a name of Sri Rameshwaram Cafe as a unit. The owner was sharing the news with me that he went to Rameshwaram Cafe personally, stayed there for 2 to 3 days, just looked into the ambience and all infrastructure, the food, the way in which it is prepared, etc. And later, he invited them to inspect his hotel. And finally, while settling the deal that he would put into his board a unit of Rameshwaram Cafe, do you know what was the response? The owner of Rameshwaram Cafe demanded 5 crores just to have to use the name of Rameshwaram Cafe. That is the goodwill that the Rameshwaram Cafe today, which has earned. So these are some of the simple examples that how intellectual property is of immense economic value. Sometimes it cannot be measured in terms of money. We do not know the potential, what the intellectual property involves until it is completely explored. So it is a business tool for business competitiveness. This intellectual property rights are a tool for business competitiveness, and this intellectual property rights are the new wealth of the nations. No doubt, this is the reason why there should be a stringent law for the enforcement of intellectual property rights. The IPR is said to be the wealth of the new wealth of the nations. This can be proved again and again by referring to various forms of intellectual property. Say, for example, if I'm supposed to tell you about the patent, why patent is to be protected, what is the very rationale behind the patent law, means it is said that patent is to be protected because of the simple reason to promote innovation. If you are going to protect the patent holder or patentee, he would, or it would encourage several others to come out with the more invention, so that it would contribute to the new wealth of the nation. And this intellectual property rights is governed by several international conventions and national laws. And to begin with, Prashant sir, kindly move to the next slide. So I'll be telling you in this slide what is intellectual property right and what are the two important international conventions that would protect the intellectual property rights. As I said, these intellectual property rights are like any other property right. We have heard of tangible and intangible rights. We have heard of movable and immovable property. And these are some of the rights that are created on the intellectual property. It's a tangible right. It's a intangible right or a tangible property. Intellectual property rights are a intangible rights or a tangible property, we call it as. They allow the creators or owners of patents, trademarks, or copyrighted works to benefit from their own work or investment in a creation. And these rights are also outlined in the Universal Declaration of Human Rights, which provides for the right to benefit from the protection of moral and material interest resulting from the authorship of scientific, literary, or artistic productions. Some of the important conventions relating to intellectual property are the Paris Convention on the Protection of Industrial Property, 1883. For the first time at the international level, three forms of property were recognized: patents, trademarks, and designs. There was no use of the word intellectual property then, because these three forms of property were called by the name industrial property. That is, patents, which can be put for industrial use and utility purpose, and trademark, which is associated with the business, and industrial design, which is also associated with the business. And in the year 1886, there was the second international convention, that is Berne Convention on Protection of Literary and Artistic Works, which comes under copyright law. So there was some sort of confusion whether copyright protection would fit in with industrial property. Then there was a use of the word, replacing the word industrial property with that of intellectual property. So this is the brief history with regard to the intellectual property rights. It was in 1886, after Berne Convention for the Protection of Literary Artistic Works in the year 1886, the industrial property, the word industrial property was replaced with intellectual property. So this is the brief history of intellectual property, and both the treaties are administered at present by the World Intellectual Property Organization, what we popularly call it as WIPO, World Intellectual Property Organization. And now briefly moving on to the different forms of intellectual property. Next slide, sir, kindly. These are the different forms of intellectual property, that is patents. As you very well know, it would be an exclusive right granted for an invention. And generally speaking, this patent provides the patent owner with the right to decide how or whether the invention can be used by others. Can anybody participate and tell me what are the requisites to get a patent? Probably for the last 3-4 days, you would have discussed this, I believe. If anybody can unmute and speak. What are the requisites or essentials to get a patent?
It should be a novel process.
Fantastic, sir. Yes, sir. Novelty, then
And it should not be copied for somebody and
fine,
again reframing it.
right,
And so basic requirements are that only. Depending on the industry, it varies actually.
right. Novelty, utility, non-obviousness.
Application and
Novelty, industrial application is utility. So these are some of the essential characteristics. It should be novel, that is new one, novelty refers to, and it should be of utility or industrial application, and it should be non-obviousness, which is not common to the people. So these are the three characteristics that is to be passed before the register of patents in order to qualify for a patent. The first stage in India is filing of application. You would have discussed at length. The second stage is examination of the application, wherein you have to pass these three tests of novelty, utility or industrial application, and non-obviousness. That means your patent is not common to the society. It is not existing in the society. Say, for example, in the refrigerator, we have cooling from all four sides. This is something a new invention. Likewise, time and again you come with new inventions which would passes this test, which qualifies for getting patents. And the term of protection of patent is, anybody?
20 years
20 years from the date of
filing.
From the date of filing. And by the time you get the patent, it requires how many years, sir?
Sir, it depends on the patent. This one, like I already
Yes.
have a patent. So if
Yes.
you go for a US patent, we got it within 3 years actually. Indian patent,
Right.
we have still not have received. So it depends on the kind of application we put and this one.
Right, sir. Let me tell you, we have something called as National Intellectual Property Policy 2016, which was unveiled to reduce the number of years to get a patent. Even in India, we require at least 3 to 4 years to get a patent. So that what I mean to say here is 3 to 4 years is lost in just getting the patent, and remaining 17 to 16 years, 16 to 17 years would be the period over which you exploit your patent. That is what I wanted to canvass. So apart from patents, there are other forms of intellectual property which would include trademark. And if I'm supposed to comment more on the process of getting the patent, as I told you, the first and the foremost stage is making an application. The second stage is examination of the application, wherein the trademark applicant has to pass the test of novelty, utility, non-obviousness, and the third stage is opposition. This is which is compared to the advanced country like US, China. We have opposition for the grant of patent, then grant. Whereas in US, the third stage is grant, then they would call for opposition. Do you agree with me, Irfan?
Yes, sir, I agree.
As you said, this is one of the drawback of Indian patent law, I can say. If I'm supposed to critically comment on the law, with regard to the four stages, we have the application, examination, opposition, grant. Whereas in US, application, examination, grant, and opposition. And if you are able to oppose it properly, defend your patent, you will be allowed to work on your patent. But in India, opposition is called for. 3 months time is given to make opposition, and if there arises any opposition, that has to be settled, which would drag the time for minimum 1 to 2 years, and it would be sometimes 5 years, 6 years for you to get your patent sealed. So from the date of sealing your patent, you will be allowed to work on that patent. So this is the condition as far as India is concerned. So this is in brief with regard to the patents, and the uniform protection is for 20 years, and prior it was 7 years in case of food, drugs and pharmaceuticals, and 14 years in case of other patents. Because of the TRIPS influence, trade related aspects of intellectual property rights, we have as of today the uniform protection for 20 years. And the next form of intellectual property that I would like to tell you is about trademark. And this is protected under the Trademarks Act of 1999, where the protection is for 10 years and it can be renewed n number of times. And the trademark can be very easily infringed over a virtual space, that is the cyberspace. And the phenomenon is called as cyber squatting. That means when you intend to start a business, not only that you start your business having the patent and associated with the trademark, but please remember to register your trademark, I mean to say to have a domain name online. If you fail to do this in the information technology era or artificial intelligence era, you would have to suffer a great setback. So not only getting your trademark registered in the physical world, but also it has to be protected in the online world with the help of a domain name. If not, somebody would acquire the domain name, which is similar to that of your trademark in the physical world. And later you would come across a phenomenon called as cyber squatting, which refers to two or more persons trying to establish their legitimate claim over a domain name, is called as cyber squatting. So yet in India, we do not have a settled law with regard to this cyber squatting. And if two persons are from India, we are applying the Trademark Act principles. And if a person is from abroad, it is very difficult to settle, wherein you have to refer the matter to the WIPO, Arbitration and Mediation Center, which would try to settle your dispute through UDRP, Uniform Domain Name Dispute Resolution Policy. So this is in brief with regard to the trademark. Moving on with the next form of intellectual property, industrial design. And this is protected by the Designs Act of 2000, and it constitutes the ornamental or aesthetic aspect of an article. A design may consist of three-dimensional features such as shape or surface of an article, or a two-dimensional features such as patterns, lines, or colors. And the next form of intellectual property would include copyright, which is protected by the Copyright Act of 1957. And Section 13 speaks with regard to the works in which copyright subsists, such as we have literary, artistic, dramatic, cinematography film, sound recording. These are some of the forms of intellectual, copyrightable work or subject matters. And computer software, is it having copyright protection or patents? Any of the audience can participate. Whether the software in India is patentable or copyrightable. Because when you talk of IPR, you should have a knowledge of all these relevant things. Patentable, Bhavyashri says patentable. Madam, in India, software can be patentable only if it is accompanied by hardware, madam. That is the law. But in US, it is patentable. This is the major difference that we have in India and the so-called developed countries. Yet India has to permit software to be patentable. It is allowing as of now to be patented if it is accompanied with hardware. That is the drawback we have with regard to Indian intellectual property laws, right? So copyright protection is, anybody as far as the protection of copyright is concerned? What is the term of protection for copyright? Because you would have come across this on the very first day when you were introduced with different forms of copyright, intellectual property rights. Anybody? Life of the author plus 60 years. Life of the author plus 60 years is the term of protection for copyright. And coming to the next form of intellectual property, geographical indications. And this geographical indications and appellations of origin are signs used on goods that have a specific geographical origin and possesses qualities, a reputation, or characteristics that are essentially attributable to that place of origin. Say, for example, Nanjangud Rasbale, Mysore silk, right? These are some of the GIs that Karnataka has. It has more than 40 GIs as of today. And most commonly, a geographical indication includes the name of the place of origin of the goods. That is the situation. This is also one of the form of intellectual property. And apart from this, we also have semiconductor integrated circuit layout designs. Plant varieties also are protected. Confidential information and business secrets, undisclosed information, traditional knowledge. So these are the various forms of intellectual property that are to be protected. Sir, kindly move on to the next slide, sir. The next is why we have to promote and protect intellectual property rights. These are some of the reasons which is listed by the World Intellectual Property Organizations at the international level. The first and the foremost reason, compelling reason to protect intellectual property is for the progress and well-being of the humanity. That is the first and the foremost reason. The second reason is legal protection of new creation encourages the commitment of additional resources for further innovation. That is the second reason why we have to protect intellectual property. The third one being the promotion and protection of intellectual property spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. Certainly, but how it is to be managed is a biggest task. Now with the invention of AI, artificial intelligence, I can go a step ahead and discuss with you this how say for example the inventions which are through AIs, are they protectable? Any discussion for the last 3-4 days you had on this? You are aware that intellectual property rights, which is a product of a human invention, can be protected. But human being comes up with an AI. If AI invents a new thing, can it be protected is my question. Audience, kindly participate, unmute and you can discuss with me. Yes, madam, Gayatri madam.
No, sir. As I know.
These are the challenging tasks, madam. As of now, India doesn't have any laws regulating artificial intelligence. But in the field of intellectual property rights, this is one of the major discussion for the last 2-3 years. The inventions. But whereas the inventions which are made by AI, the answer is yet to be, we have to get to know as far as intellectual property rights invented or by the AI is concerned. And the next step is with regard to the promotion and protection of intellectual property rights. It spurs economic growth, creates new job and industries, and enhances the quality and enjoyment of life. And the fourth reason why this intellectual property is to be protected and promoted is to realize intellectual property potential as a catalyst for economic development and social and cultural well-being. This is also one of the main reasons why intellectual property deserves to be protected. And the last reason is to strike a balance between the interest of the innovators and the public interest. This is very compelling reason for a country like India. We are in the tier 2, that is developing country. It becomes very important not only to encourage intellectual property rights in India, but also to strike a balance with regard to the public interest. Probably when we talk of patent law, obviously you would have come across something what is called as compulsory licensing and revocation of patent for non-working. This compulsory licensing speaks with regard to the withdrawing or asking the patent holder to share his license with the interested person to work on. Because the law, as per Section 84 of the Patents Act 1970, which advocates that the patent once granted has to be made use or made available throughout the territory of India. Say, for example, you would be given initially 6 months or 1 year time. And still, if you are not able to produce the patented article and look into that article is available throughout India, there can be assignment and licensing. These are the two aspects that one has to be aware of, because law doesn't permit you just to have a patent and keep it at home. Because I have a number of things to be discussed when exclusively with regard to the law of patent. Have you heard of something called as evergreen patents? If anybody is from pharmaceutical sector, evergreen patents. Nobody? These evergreen patents are patents made by the pharmacist. They make an application and keep quiet and saying that we are still experimenting. That is why the law of patents has been tightened now. You can make a preliminary application within 12 months. You have to compulsorily file complete specification. Preliminary application or specification, from the date of filing the preliminary or the primary application, within 12 months, you ought to compulsorily file complete specification. That is the requirement under the Indian patent law. So there are a number of changes that has been brought about. So these are the compelling reasons why we have to protect and promote intellectual property rights, as said by the World Intellectual Property Organization. Sir, kindly move on to the next slide, sir. So how do an average person benefit from the intellectual property? This is very, very important. So this intellectual property rights reward creativity and human endeavor, which fuel the progress of humankind. There are ample of examples that I can give you, not only from WIPO, but also some of the examples from our own place. As I said, this multi-billion-dollar film recording, publishing and software industries, which bring pleasure to millions of people worldwide, would not exist without copyright protection. Do you agree? As of now, the blockbuster films, right, would fetch you not less than 1,200 crores or up to 1,500 crores. There is a competition. You would have seen Pushpa 2, or there are a number of films. Even Kannada film is been able to shot, or they are able to make pan-India films. And without the rewards provided by the patent system, researchers and innovators would have been left with little incentives to continue producing better and more efficient products for consumers. So this is another important reason. So if there is no patent protection, the inventors would not have come forward. The very historical background of patent law says this. If you look into the very history of patent law, it was the food recipe which was exploited, or which was prepared by the chef in the Emperor Zeno. The history of patent law speaks with regard to this. That was much before the death of the Christ. It was in BC, before Christ. Emperor Zeno had given protection for a chef who prepared a recipe. That was the very basis for the patent law, to develop patent law. He said, other than this person, nobody else should prepare this recipe. That is the reward I am going to give him. And initially he was given for a period of 2 years. Except him, nobody can prepare this recipe. That was the way in which a particular chef prepared a recipe. This is how the historical background of patent law developed. And consumers would have no means to confidently buy products or services without reliable international trademark protection and enforcement mechanism to discourage counterfeiting and piracy. So these are the reasons why intellectual property deserves protection, right? I have given different justification for the copyright, patent and trademark. Apart from this, we have several types of justification: labor justification, economic justification, property theory. There are different theories which speaks with regard to the very protection that is to be given to the intellectual property rights. Moving on to the next slide, I would just distinguish between the intellectual property and industrial property. As I already said, way back in 1883, through Paris Convention, 3 forms of property were recognized, such as patents, trademarks, and designs. There was no use of the word intellectual property then, till 1883. And it was in 1886, through Berne Convention for the Protection of Copyrights, the protection for copyright was included at the international level. Copyright covers literary works such as novels, poems, and plays, films, music, artistic works such as drawings, paintings, photographs, sculptures, and architectural design. So, in order to protect the copyright, the word industrial property was not very much suitable because copyright cannot suit to the industrial property. So, there was a coining of word what is called as intellectual property. Intellectual property are those property which is a product of human intellect, human mind, human creation. The biggest challenge that we are facing to protect intellectual property as of today is because of human intelligence, you have artificial intelligence, no doubt in it. Artificial intelligence, which includes machine learning, deep learning, etc. The question today is, if this artificial intelligence is able to produce intellectual property, who deserves the protection? Is it the artificial intelligence which invented that intellectual property, or the human being who invented that artificial intelligence? This is the biggest question to be answered as of today, and we require more clarity on it. And it is only the European Union as of today which has law relating to artificial intelligence. That is the situation. So this is with regard to use of the word industrial property and intellectual property. Hope if the concepts are clear, can I move it further, or is there any questions? I sincerely request you to unmute and speak because I'm not able to go to the chat box since I have joined through my mobile phone.
Sir,
Audience, yes,
I
madam.
am having a question.
Please, madam.
See, nowadays artificial intelligence is in boom. Okay. Do you think it is good for society and getting patent all those in future, all those? I don't, my opinion is not good. But since
Madam.
you are being an expert, I'm asking you.
Yes, madam. The moment you say that it is not good to the society, will it be taken back? Is the first question. Let me give you one example trying to convince you. Probably everybody would have been heard of online gaming. Online gaming, fantasy games, all these we have heard of. A cyber expert says till a particular sum of money, maybe 5,000 or 10,000, you will have a chance to win. That is how exactly an online gamer starts getting addicted. He would start with 100 rupees, he would start with 500 rupees, he may start with 1,000 rupees. As he goes on playing, he gets some money back so that he's more addicted to play online game. And as a resultant of which government of India came down heavily on online gaming, the matter went before the Supreme Court of India. Supreme Court said, when other countries are permitting for online games, why not India? So it was restored. Now the cyber experts say online gaming platform would allow you to make money up to 10,000. After 10,000, if you bet, you keep on losing money so that you lose entire money what you play. Today morning, I just received one of the message. A person forces another to get his boot polished. Even he was not wearing the boot, he was wearing a slipper. And it was not a reel, it's a video of 1 to 2 minutes. We require a lot of patience. After this, my class, I will be forwarding this video with the permission of the organizers in the WhatsApp group. Please go through that video. He says, I'm going to brush your shoe. He says, no. Then he doesn't leave him even after a minute. And he asks, what is the reason for you doing this? He says, online gaming. How much you have lost through online gaming? 40 lakhs. An youngster aged about 22 or 23, if he gets addicted to online gaming, this would be the result. Coming to your artificial intelligence, madam, there are pros and cons. But law has to be developed in such a manner to overcome the disadvantages of artificial intelligence. Probably, if I'm supposed to give you another example, if you have seen this film of Rajinikanth, what is that, Robo? Probably most of you would have seen this. Insertion of one chip to Robo would make it very destructive. It is filled with destructive energy. what I want to canvas here is artificial intelligence is to be used in such a manner so that we are supposed to take the advantages. If I'm supposed to give you another example, impact of artificial intelligence on legal profession. I'll be telling my students, you will be outdated if you don't learn the skills. And how to do this? You have to overcome the use of artificial intelligence. And you should professionalize yourself to use artificial intelligence so that you will be above artificial intelligence and you can manage that artificial intelligence. Because any assignment that we give to a student today, you find the answer through ChatGPT or through this AI, which is not acceptable. Even lawyers abroad in America have started using this AI to frame their petition, which is outrightly rejected by the courts, and they have been exemplarily fined. This is the situation. So, madam, the answer to your question is we cannot say that we should go back from AI. We have to accept the technology, but law has to be framed to overcome the disadvantages of technology. For example, OTT, over the top. We have few regulations to control it. Digital Media Ethics Code 2023. But in a stringent manner, there is a need to regulate all these things. Madam, anything to share? You unmuted yourself, Gayatri, madam.
Sir, what I want to say, no, nowadays,
Yes, ma'am.
when I have been attending some meetings in the college,
Yes,
there is in higher level bodies, they
yes,
used to say that introduction of artificial intelligence in the UG level only. Say, of course,
yes,
I agree that if it is above the master and almost after master degree, by that time that students get matured so that
yes,
they know how to handle it. But
yes, madam.
introducing artificial intelligence in UG level, only in theory aspect, it's okay. But if it is applied in practical aspect, I think many of our younger generation will lose job. Of
Right,
course, I agree. Artificial intelligence is helping us, but at the same time, it is bringing so many drastic effects, and legally it needs more control over that. But I hope it is not properly managed. It will be
of course,
properly managed.
of
And
course,
even my students are getting answers through the chat GPT only. They are not going for any library, anything else.
yes, madam. I do
This is
agree
what
with
I
you.
am telling.
Definitely, I do
Technology
agree.
is good, but the utilization we have to properly channelize that.
Definitely, it is very much required, madam.
Uh,
Yes, madam.
Sir, myself, Professor Ranjini from Saramvi Science College, Bhadravati. I would like
Yes,
to add to the discussion which was going on just prior to the person who interacted with you. So they were telling AI is having more of a disadvantages than the advantages. So recently I had attended the one FDP program in DOS in biotechnology. There we had an opportunity to interact with the chairman of that is a professor from computer science. And since we are from biotechnologists, we have ethical issues to use the animals and animal products, or on our own risk, we cannot use the animals for the research or for my benefit. So we have the ethical issue. I just raised this issue in the gathering, and he said the government has initiated the ethical clearance board, what we have like that, for also AI to control the phishing or disadvantages which are hurling the normal life of the human beings. So they have taken the computer science faculty members from University of Mysore, and the government is taking initiation to stop online cheating and phishing and all those things. So we have to go with the software, but we should be smart and we should have the regulation, and the state has already taken the initiation, and even from the Karnataka there is a representative for this committee, and we are glad that our university computer science faculties are involved in this committee. So I
right.
hope this will not threaten our life in the future days. Not only
Right.
us, and also the next generation. We have to be updated, and at the same time, we have to accept when we are updated, we want only the good part of the app or good part of the software. We cannot do like that. We have to manage with the disadvantages as well. So we
Yes,
have
that
two
is
kids
where
means
exactly.
we have two kids means one will be very wise and another will be very naughty. We will
Right.
bear that. So like that. So the software will be there. We have to compete globally, and we need to have a advantages at the same time with the precautions and warnings what AI is having. So that is more important. So I hope this whatever the FDP program or training programs you are giving on the IPR is eye-opening sessions are handled from past many days. So it will be useful for the many researchers and the professors also. Thank you, sir. You are giving a very good lecture. Thank you, sir.
Thank you. So, as two of the audience shared their views, and I saw some of the messages, Sardar Hussain said we have to learn and accept AI very much. Yes, because we have to live in a competitive era. It's very compelling that we have to overcome the disadvantages of AI and move further. Sir, kindly move on to the next slide, sir. Prasan, sir. Let me tell you something about National Intellectual Property Rights Policy, which speaks of Creative India, Innovative India. There is a vision statement and mission statement. Probably after the program, this PPT would be shared to you. The vision statement focuses on the creativity and innovation, which are stimulated by intellectual property for the benefit of the all. This is the vision statement. And coming to the mission statement, it stimulate a dynamic, vibrant, and a balanced intellectual property rights system in India to foster creativity and innovation and thereby promote entrepreneurship and enhance socio-economic and cultural development, and focus on enhancing access to healthcare, food security, and environmental protection, among other sectors of vital social, legal, economic, and technological importance. So this is the vision and mission statement of intellectual property rights. And there are 7 important objectives with which this policy is being passed. Kindly move on to next slide, sir. These are some of the important one. IPR awareness. First of all, we have to create awareness about IPR, outreach and promotion, generation of IPRs, legal and legislative framework, IPR administration and management, and commercialization of the IPR, enforcement and adjudication. This is where exactly the offences relating to IPR and the cyber crimes comes. When you talk of giving the intellectual property rights or conferring the intellectual property rights to the inventors or a copyright holder or a trademark holder or any stakeholder for that matter, protecting the same for next 16 years from the date of sealing the patent is very important. You have conferred copyright on a particular subject matter that has to be protected for the term life of the author plus 60 years. And trademark is to be protected for 10 years. And every once in 10 years, it can be renewed. Say, for example, if I ask what is the best TV you would choose, answer would be the best TV which you would like. Anybody? The brand of TV?
Sony.
Sony. Why you are able to distinguish Sony from others? Everybody knows Sony, LG, Samsung, etc. Trademark is going to distinguish your goods and services from that of the others. That is the remarkable feature of trademark law. That is why intellectual property rights are to be protected. Human capital development. So these are the 7 objectives with which IPR policy has been unveiled in the year 2016, and the period of giving, the process of giving or conferring the intellectual property rights over the applicants has been reduced. So this is in brief with regard to intellectual objectives of the intellectual property policy. Kindly move on with the next slide, sir. I have just expanded the objectives. Please go through it. Move on with the next slide, sir. Right. The next slide. Let me speak on enforcement and adjudication, where offences, previous one, sir, previous one. Enforcement and adjudication. To strengthen the enforcement and adjudicatory mechanism for controlling IPR infringements, to build respect for IPR among general public and sensitize the inventors and creators of IP on measures for protection and enforcement of their rights, to build the capacity of enforcement agencies at various levels, including strengthening of IPR cells at the state police forces, to identify and undertake measures to check counterfeiting and piracy, to arrange regular IPR workshop colloquia for judges to facilitate effective adjudication of IPR disputes. See, not only conferring IPR is important, but protection is equally important. When somebody infringes your intellectual property, patents, what to be done, where to approach. That is the situation. To adjudicate on IPR disputes through specialized commercial courts and explore alternative dispute resolution mechanism, since it involves huge high stakes. There is a need for alternative dispute resolution, that is settling the dispute outside the court. That is what we call it as alternative dispute resolution mechanism. Sir, kindly move on with the next slide, sir, please. This is with regard to human capital development, right? And moving on next, after telling you the next slide, sir, the general things about the intellectual property rights, I thought of, let me focus on patents, since the FTP was on patents. What is the very purpose of patents? Legally speaking, this historically it says, patent protection was designed to encourage innovation and to disclosure of the details of new inventions. Because inventors may be hesitant to publicize their creation, lest someone copy it. Patent protection provides an incentive to share ideas with a temporary monopoly on their use. See, this is something important. In country like India, you cannot consider it to be an exclusive monopoly. There has a balancing of some of the interest, such as if patent is conferred as an exclusive monopoly right, how you would protect the medicines? You cannot charge the medicines at an exorbitant price. So government of India is having a control over such patents. And there is no patent can be granted with regard to nuclear or atomic energy. This is another important thing. There cannot be any patent granted with regard to the currency. These are some of the very important areas that one has to analyze. Can you get a electronic voting machine as a information under RTI? Anybody? Electronic voting machine.
No, sir.
Because of the reason that it has been patented. If not, we would have given that EVM as a information under Right to Information Act, which includes information, includes samples, models, data materials, etc. That is the situation. So this is the full invention is disclosed in public, in publicly available application, because you are given with 20 years of protection. Kindly move on to next slide, sir. What is patent infringement? This patent infringement is a violation of exclusive right of a patent holder. A patent is a license which confers an exclusive right or a title to the inventor for a set period of time to exclude others from making, using, or selling an invention, and the violation of those exclusive rights or title of the patent holder is known as patent infringement. This is what I mean to say offences relating to IPR. There can be an infringement of patent, infringement of trademark, infringement of copyright. This is the word which we use. Infringement of geographical indications. Rasbale, Mysore, Nanjangud Rasbale cannot be grown in Jammu and Kashmir. You cannot sell Kerala Bale in Mysore, calling it to be a Rasbale. Probably you have come across this, I believe. Most of you are being duped, saying that it is Nanjangud Rasbale. It would be something hybrid grown in Kerala or Tamil Nadu, what we call it as Card Bale. These are some of the examples. So patent infringement, it involves activities like unauthorized use, production, sale, or offer of sale of the subject matter or invention of another person's patent. So this is with regard to patent infringement. Kindly move on to the next slide, sir. Remedies for patent infringement. Section 108 of the Patents Act deals with relief. I have listed the remedies available for patent infringement. You can ask for injunctions, that is stay orders. You can ask for accounts for profit. If your patent is infringed, you can ask for accounts for profit. You can ask for damages. You can ask for other actions. These are some of the remedies available for patent infringement. Kindly move on to the next slide, sir. So I have attached two of the documents which will be forwarded to you in the group. IPR enforcement toolkit for police and IPR enforcement role for custom authorities. You will come across how these patents, trademarks, especially with special emphasis to trademark and copyright, the role of police is very important. With regard to a patent, when you file a complaint, they will come and make search and seizure. If there is a clear evidence that your patent is been infringed, they can make a search and seizure of the infringed objects and submit it to the court, and appropriate action can be sought against the person who has infringed your patented article or goods. Moving on with the next slide, offences relating to intellectual property rights. Kindly, sir, next slide. It includes the following types of crimes, such as copyright infringement, unauthorized reproduction, distribution or performance of copyrighted material, trademark counterfeiting, creating and selling goods that use an unauthorized version of registered trademark, patent infringement, making, selling or using or selling a patented invention without authorization, trade secret theft, unauthorized acquisition or disclosure of confidential business information, piracy, unauthorized copying or destruction of distribution of copyrighted works, often involving software or media, counterfeiting, that is creating the fake versions of goods that mimic real products, often deceive consumers. So these are some of the list of intellectual property offenses. Moving on with the next slide, there is a imprisonment, there are fines, seizure of infringing goods, and these are some of the legal framework. Copyright Act 1957 is there, Trademark Act 1999 is there, Bharatiya Nyaya Sanhita 2023, that is the Indian Penal Code which was replaced by this Bharatiya Nyaya Sanhita, and Information Technology Act 2000. If a crime is done using online, we call it as a cyber crime. Trademark is infringed online, we call it as cyber squatting. Copyright is infringed online, we would take the provisions of Copyright Act, Bharatiya Nyaya Sanhita, BNS 2023 and Information Technology Act 2000. These provisions are taken to make an FIR in case of a online copyright infringement. Patents are usually infringed. There is no online infringement of patent, right? Because it is a intangible right over a tangible thing. That is why patent would not be infringed online. Copyright and trademark can be infringed online. And coming to the remedies quickly, with regard to the intellectual, that is remedies relating to infringement of patents, as I already told you, injunction order, accounts for profit, damages. These are some of the the remedies that are available in case of an infringement of a patent. And the injunction order, in order to get an order of injunction, three things are to be proved: balance of convenience, irreparable harm, loss, injury, and damages. If these three things are proved by the applicant or a plaintiff that my patent has been infringed, the Honorable Court would be pleased to pass an ad interim ex parte temporary injunction. That is, without giving opportunity of being heard to the other party, an injunction would be passed against him not to infringe your rights. Similarly, accounts for profit speaks with regard to if he has made any illegal profit using your patented, using your patent. That means he has passed off his goods saying that it is his. So passing off using your patent, he has to account for profit, and you can also claim for damages. So these are the important remedies available in case of infringement of patents, right? And moving further, you have, so these are in brief with regard to the offenses relating to intellectual property rights and cyber crimes. And to tell you specifically on cyber crimes, the important forms of intellectual property that are where cyber crimes are committed are trademarks and copyright, right? Trademark can be violated online that is why I said when you start a new business, not only you get associated with the trademark, but also get a domain name. Do not forget to register a domain name. And when copyrighted work is to be protected, you have to be very careful when you publish your work. Once you publish it, prior to publishing, you take a copyright. After getting the copyright, publish it. Right? Once you publish it, it cannot be copyrighted because it has fallen into the public domain. So these are some of the things what I wanted to canvas. Right? If you have any questions, you are most welcome. The PPT and the material, that is IPR enforcement kit to the police, will be shared with you in the group, or I would request Prashant sir to share it in the group. If you have any questions, you are most welcome.
Thank you, sir. It is very informative and insightful information.
Yes, sir.
Audience, if you have any questions, you can unmute yourself and ask the question to resource person, or you can put it in a chat box also. I think there will be no questions from the audience. Over to Brunda, ma'am.
Good evening, everyone. So Bharti ma'am is going to address the gathering. Bharti ma'am?
Ma'am, you are not audible.
Not audible.
You are audible, ma'am, now.
Okay. Now I'm audible.
Yes, ma'am, you are audible.
Okay. So, resource person. So, good evening to all of you here. Resource person for today's session, Mr. Jagdish A.T., Assistant Professor of Law, JSS College, Mysore. My dear colleagues, faculty from other colleges, and participants, it is my pleasure to address you all on the occasion of the final closing day of this 5-day faculty development program on intellectual property rights. First of all, I congratulate all participants for successfully completing the program. Intellectual property rights play a vital role in promoting innovation, creativity, and research. As an institution, we recognize the significance of IPR in fostering a culture of innovation and protecting intellectual assets. This FDP has equipped our faculty members with a deeper understanding of IPR, enabling them to support students, researchers, and innovators. I'm confident that this knowledge will contribute to our institutional growth and reputation. I would like to express my gratitude to the resource persons and participants for their dedication and enthusiasm. I would like to extend my special appreciation to our IQAC coordinator, Srimati K.S. Sukruta, for her exceptional initiative in organizing this online FDP on intellectual property rights. Her dedication and leadership have been instrumental in making this program a successful one. I also appreciate the efforts put by all NAC coordinators and members for joining our hands with us for the successful completion of FDP. All your collective efforts have made this FDP a success. I look forward to seeing the positive impact of this FDP on our institution's research, innovation, and academic initiatives. May this FDP inspire us to protect and promote intellectual assets, fostering a culture of innovation and excellence. I wish you all the best in applying your knowledge of IPR to drive innovation and excellence. Thank you, one and all.
Thank you, ma'am. Thank you for addressing the gathering. Acknowledging the good that you already have in your life is the foundation for all abundance. Even in this virtual space, the exchange of ideas surrounding intellectual property right has been truly illuminating. It's wonderful to see so many engaged participants joining us online to explore this vital aspect of innovation and creativity. I'm honored to deliver this vote of thanks for what have been a very insightful online session on IPR. On behalf of all the participants of this enriching 5-day faculty development program, I extend my deepest gratitude to our esteemed management and to our respected principal. Your vision and support in organizing this comprehensive FDP have been invaluable in enhancing our understanding of this critical domain. We truly admire your commitment in fostering knowledge and professional development. Thank you for the management as well as our beloved principal, Bharti ma'am. We thank you. I extend my sincere thanks to Dr. Ullas, CEO and Deliver Ed iSimon Software Service, CCP Mysuru, for delivering such an insightful and comprehensive lecture on the introduction and overview of IPR. His expertise and clarity in the explaining the fundamental concept have provided a strong foundation for all of us during this FTP. Thank you, Dr. Ullas, for sharing your valuable knowledge with us. This was the first day topic on the FTP. And we are deeply grateful to Ms. Sai Priya Balasubramaniam, a registered Indian patent and trademark agent and independent practitioner from Bengaluru, for her insightful lecture on national and international framework of patent. Our expertise and practical perspective have greatly enriched our understanding of the complex yet crucial area. Thank you, Ms. Balasubramaniam, for sharing your knowledge and experience with us during this FDP. We extend our sincere gratitude to Ms. Sunetra Debali Sudhakar, patent attorney and Ed Manager, Life Sciences, SNH Partners, Bengaluru, for her insightful session on the patent life cycle and patent filing on the third day of our FDP on IPR. Our expertise and practical insight have been invaluable. Thank you, Ms. Sudhakar, for sharing your expertise with us. We express our heartfelt gratitude to Mr. Irfanullah Sharif, Chief Scientist Officer at Prozi Healthcare, Mysuru, for his engaging and informative session on trade and trade secret, as well as copyright protection and infringement, which he delivered on the fourth day of these sessions. His expertise offered a unique and valuable perspective on this crucial aspect of intellectual property. We truly thank you for sharing your insights with us, sir. Thank you. I would also like to express my gratitude to Dr. Jagdish Eti, Assistant Professor of Law, JSS Law College, Mysuru, on the topic Offences relating to IPR and cybercrimes. Your insights into this evolving landscape have undoubtedly broadened our understanding of the legal and technological challenges we face today. Thank you for shedding light on these important matters, sir. A special thanks to Srimati Sukruta KS, IQSC Coordinator, Head Department of Computer Science, in showing her key interest in initiating and streamlining this 5 days FDP on IPR. We are immensely thankful to you, ma'am. I thank sincerely to all the dedicated IQSC coordinators and hard work of you all from the day one in engaging this program. Thank you all. My deep sense of gratitude to all the participants for your enthusiastic involvement and active engagement throughout this program. Your keen interest, insightful questions, and collaborative spirit have been instrumental in making this FTP a resounding success. We truly appreciate commitment to learning and your valuable contribution. Thank you all. My special thanks to all my dear teaching and non-teaching faculty who made the program effortless and successful one. Thank you one and all present on this platform. Thank you for the opportunity for me on thanking the all audience and all of you. Thank you, sir. Over to you, Prashant, sir.
Thank you, ma'am. Thank you, Jagdish sir, once again.
Fine, sir. Thank you.